Recording. All right, good afternoon, everybody. Happy Thursday. Welcome. Our normal webinar for Thursday. Here's the agenda. As always, these aren't required. If they're beneficial, great. If you have other things you need to do, we record them and post them. Just for full transparency, it's taking, we're usually not getting them up until about Monday now because of the using Zoom and how many other people are using Zoom. By the time it gets rendered, usually isn't until about 24 hours. So we try to get them up as fast as possible, but it's usually about 2 business days to get them up. That's what seems to be the process right now. Our agenda's up, assessment decision-making, complaints processing, mediation processes, and just general updates. If you have questions, go ahead and throw them in the Q&A and we'll address them as we go, or if they're larger scale questions, as always, we'll run them through the disaster info. If you have questions after this, please outreach disaster info and we can process them. And we'll go through it like that. And I think that's it for the general announcements. So with that, I'll turn it over to Jose, who's going to talk about assessment decision-making.
Thanks, Ed. First, I want to thank you guys for the opportunity because in the last probably 10 days or so, we have received an influx of questions about a change we made to one of our assessment documents, our guide to accessibility. The change we made, we've been responding this over the phone for a couple of years now. So we got some feedback and it was time to put it on paper, right? And what we edited on our manual was the idea of not having to document the mode of testing between paper and online on a student individualized paperwork unless there's an absolute need. That is not a change in policy. That's always been the case. But I think it may have been emphasized that should not document the mode. So what do I mean? Please understand that we're not taking away any of the faculty from our committee. First of all, because the assessment division of TEA has no authority to do that. But what we want to make sure is that we don't lock a student into a mode of testing, especially for paper, that is so limiting unless it's an actual need. So let's use as an example. To me, it's always easier to walk this in using an example. Oral administration. The accommodation is to receive the content of the test read out loud. That could be delivered in either paper or online. So what we're saying is you don't have to document that it needs to be on paper or online unless there is an actual need for that, which sometimes there is a legitimate need to document the mode of testing. For example, we know we have students who too much exposure to a computer monitor can trigger some kind of physical reaction. In those cases, yes, the mode of testing, meaning paper, becomes the accommodation that they receive. So they should, our committee should document that on the paperwork because it's important that we make sure the student gets the right mode. But those are very small number of cases, right? For the majority, if a student needs to have the content of the test delivered out loud, meaning oral administration, then we should make the decision of the mode after we have enough time to expose the students to both modes and decide what is the best mode to allow the student to show their mastery, right? The problem is if we keep that without a real need on the paperwork, as you know, we're going to do what's on the paperwork. So for instruction, they're going to stick to paper only. And we are shortening those students of a much more enhanced opportunity because through a speech to text, as you know, especially as these students move up on the grade levels, they become a lot more self-conscious the day of test when we have to pull them out of the classroom from one-on-one test administration. And we know they're not going to raise their hands to ask the TA to repeat the content because they're embarrassed. However, if they have enough exposure through the year to work with our text-to-speech engine, learn how to re-click on words, to highlight and read and listen to the text again, that can provide them a better experience for testing. So that's the whole point of it. It's not that we're removing away any faculties for the art committee, because first of all, we can. What we're saying is you don't have to write the mode of testing unless it's part of the accommodation the student needs. So another question that I got is, well, Jose, are you telling me that I need to go back and change all my, have additional meetings so I can amend all my paperwork? Well, again, we can force you to do that, but I believe it's in the student's best interest that you revisit that decision. And once you move it out of the paperwork, because it's not part of the accommodation, there's no need to document that at all. So we're not saying that you should go and remove it. What we're saying is it should not be there in the first place, because this way you can afford the whole year of instruction to try different strategies and provide the student the best mode tied to what they need. I promise you that makes sense in my head, but I want to see the questions and reactions.
I'll say there's a question in chat that's not really related to whether or not to document, but it says it's got to do with testing coordinators pushing to know the number of kids who are testing online because they have to get that number submitted to the testing contractor. So that, but that they, like they have a couple of opportunities to adjust that information, correct?
That is correct. And it's actually the source of, most of the source of this whole dilemma, right? I live in a world where I'm trapped between what special coordinators need and what testing coordinators need. So what I've learned the last couple of years from interacting with all of you is that this is more a problem of how are we organizing the transferring that information for testing. Because we document that on our district SIS services, that is the easiest way to market, so we can produce a report for testing coordinators of what they need. Unfortunately, that information is coded under the paper or the accommodation section. So if we can fix that just by working with SIS, yeah, I mean, you should have a way to electronically document that is easier for you and it doesn't make your life harder. What we're saying is it should not be part of the accommodation decision section because the mode is not, unless for the small number of students who have a real need to have it documented. And as Justin said, there's plenty of opportunities to adjust the ordering. So if you're getting pushed from your testing coordinators that, oh, but I need to know those numbers earlier. No, we have what we call additional orders that run very close to the assessment window, especially to make all these adjustments. Now, can we adjust the mode for the whole district? No, but we're just talking about this small group of students. Let me check the chat for additional questions. Where can I see this in writing? It's page 5 of the STAR Educator Guide to Accessibility, which is posted on our website under accommodation resources or under the district coordinator resources. Let me send the link to the guide to Ed, and Ed, hopefully you can put it on the notes you're going to send from this meeting so everyone can find the right documents.
Yeah, we can send out anything afterwards. That's easy.
There needs to be a TA letter notifying districts of this. It's a big issue and all district personnel need to be on the same page. Yeah, I think that the problem here has been communications, and that's where I personally need your help, and also I need the help of the same group of testing coordinators that I meet with every Wednesday. I'm gonna be super clear again. The policy has not changed. This should have always been the case. So what we're saying is clarifying what the policy have always been. But you're right, we can probably look for better ways to communicate this. So there's another question, again, asking, do we need to go back and have another meeting to fix the paper to show? Well, as you all know, the paperwork should be correct, should demonstrate exactly what the student needs, right? So what we're saying is, if right now you're making decisions, the student needs oral admin on paper, if there's not a real need for that, then it shouldn't say paper. It should only say the student needs oral administration. As we get close to the testing the testing administration, you will decide what mode is more appropriate. If you decide that online is more appropriate, then you let your testing coordinator know so they can activate that on the system, but you don't have to change your paperwork. Your paperwork does not need to say text-to-speech online. It just needs to say oral administration for a start.
I would just want to jump in real quick to address that question. If you've already done that, if it's already in the IEP that the student's going to test on paper, then I would say that if that kid's not going to test on paper, you're going to want to amend and change that. When you come to your annual, I would, according to what Jose is saying, just take it out, like not be moot on whether, just address accommodations, address that sort of thing, but don't address what the mode of testing is going to be. However, if you already have it in an IEP, and that's not what you really think is the best thing for the kid, because by the time we get up there, you might have other information, and you want these kids testing in the mode that's going to be best for them. If it's not what's reflected in the IEP, I think that's okay, but you should. I would go through in those cases. I would go through the amendment process and change that in the IEP. Just because you don't want to be, because you've already put it there, you don't want to do something opposite of what you already have in the IEP, because that was agreed upon, and that's binding. So if you don't have it there, you're good. But if you do have it there and you're going to do something other than what you've listed in the IEP, I would amend that. And then at annuals, when you come up in annuals, just take it out.
Thank you. That's a great clarification, Justin. There's also a couple of questions now about content language supports, which are delivered online. We do have an exception of content language supports on paper that has to be approved by our division. Again, because we need to understand that the mode in that case is fundamental for a student's need, right? Because as you know, the experience of content language supports on paper is much more reduced than what we can offer online. Online, we can offer animations, color pictures, stickers, or pop-ups and rollovers, which we cannot do for paper. It still depends on a child requesting the support from the TA, and we know that students become shy and they don't ask for that. Kim just put a clarification that an amendment is sufficient. You don't have to be a full R, so thank you for that. That's a really good point.
Yeah, sorry, I meant to say that if I didn't.
So there's another comment about having students who cannot test on a computer. I'm assuming that it's because of an individualized condition. Yeah, those are the cases when you will want to add the mode of testing to your paperwork, because you're saying that for those students, the mode of paperwork actually becomes part of the accommodation. For example, you have a student that if you put a paper test in front of them and they're going to tear it apart, well, you know that then you don't want to do that for the day of testing because you want to afford them the best opportunity to show mastery of the skills. So those are the cases when the mode becomes part of the accommodation. I keep going through comment. Okay, so I have questions from the chat and on the Q&A, so I'm trying to balance both. Give me a sec, please. What if the committee did not document the mode? Do they need to do an amendment? No, again, you're documenting the accommodation only, right? So if that's what's on the paperwork, you're golden, you're fine. As we get close to the test, depending on the opportunities we have afforded the student to practice and be exposed, you will decide if you want to take it online or paper. However, if you're talking about a case of content language supports, those are delivered online. So it's automatically, by default, the mode has been determined for these students.
The only case where you would have to do that is if you're, like they're asking specifically about the PNPs. If you're doing something different in the personal needs and preferences than what you originally planned on, then you do need to amend that. That's the case for anytime you're doing anything different than what you said there. And we want you to be open to doing things differently because kids' needs change over time, especially if you did their annual in May of last year and it's going to be a whole year later. There might be something different that's available that might work well for that kid, and so you want to be open to doing that.
That's a great point, Justin. So thanks for raising it up, because I will say my recommendation will be that this is the year to start promoting that move. Because remember, we have a mandate to add to the type of items we include on our STAR test, which will be what we call technology enhanced items. And those are going to be delivered online only. So now is the right time to transition and get students comfortable with just a plain or multiple choice test online. So then we end up adding those additional items. The transition is easier for them.
So Jose, there's a question about who makes the decision about mode of testing if the art committee does it. We've always answered that, you know, whoever knows the student best, usually the classroom teacher or the folder teacher would make that, dependent on, you know, practicing with the online tutorials, any other kind of online remote work that the student's been doing, how do they navigate it, versus paper, and determining which mode is going to be the most accessible for the student. They're still going to get their accommodations on the mode. They'll get an oral administration, whether it's online or paper. You would just choose the mode that's most accessible to the student closer to testing, and let the testing coordinator know.
Which again is the same cycle, right? So if you don't have it on the paperwork, then your teachers will be more open to try different strategies, and then you can make the best decision. So there's always this power struggle in schools between the special ed coordinators and the testing coordinators. But really, who has the power is the student. We should always decide what affords the student the best opportunity to show mastery of their skills.
There's a couple I've seen come up a couple of times about parent input into this, and so that should be discussed at the art committee meeting of that, the process that you're going to go through to get to that. Mom and dad or guardian, whoever we're talking about, should know what the process is going to be for making this determination. If there is, and Jose's already mentioned this, if there is a reason why a student really should only test in one mode or the other for like a very good a reason that folks are clear on, then go ahead and put in the art, agree on it then, like do that. Like we're not telling you can't, we're saying that you don't really have to, and it gives you that flexibility to make those decisions closer to testing time that are as appropriate for that kid as possible. Because if that's not the case, if there's not necessarily a reason why a student has to test either online or on paper, then one of those two modes might not be the same every year. What's going to be better for that kid? You might have a younger kid who, for instance, is much more comfortable on paper, but as he gets older and more comfortable with technology, man, he's accessing apps and he's doing all kinds of stuff. Especially, guess what? After this last 6 months of virtual instruction, there's gonna be a lot of kids that are a lot more comfortable with technology than they were before. And so they might be better off being able to take advantage of some of those built-in supports. Jose talked about how when kids get older, they're less likely to ask for those supports if they have to be given in person by a test administrator. I've seen that 100%, seen that live happen. And so as you want to have the this is giving you the flexibility to adjust as needed. The kids, but if you have a scenario in which only one testing mode is appropriate for that child, then go ahead and document in the art. That's fine.
Justin, and in those cases, because I get it, I answer these questions a lot. Sometimes the line is a little blurry. Please give us a call. Let's have a discussion. See if we can help you make the best decision for the child. We're here to help you. I also want to address Linda's question, because this is, to me, is one of the root of all this confusion. So the SIS vendors that handle your paperwork, they're not a state vendors. So we can't tell them what to do. They work for your district. So your district has the power to ask them to change how they record information. Absolutely. Right now, it seems like we got used to these systems collecting that mode of testing information where they shouldn't really be. Now, can you do it? Yeah, you should still do it. Just move it out of the student's paperwork. Because remember, just like Justin says, you have to do what it's listed there the day of testing. So let's make sure that is what affords the student the best opportunity. Unless you guys can find something else, I believe we addressed most of the concerns. They were all similar.
And Jose, if there's something you want me to send out or us to send out, we can happily get that out. Just get that to me and we'll blast it out to through the email, just like we do for the agendas for these, so folks can get it.
Yeah, thank you. The document is our guide to accessibility, which surprisingly, we added the phrase about the mode of testing, but the phrase about making decisions as close to the assessment as possible has not changed, right? But that was the whole point. that so that you can make decisions as close as possible, you shouldn't list the modes of testing because that kind of traps you on that decision, or locks you, not traps you. Apologies, I'm an English learner also, obviously.
Okay. Well, thanks for taking some time to talk with us and folks today. So next up, Keith Swink, manager in the complaints division. He was going to talk through the complaints process a little bit. All right. Are you ready, Keith?
Yes. Hi, good afternoon. So I was asked to just review the complaints process, maybe answer any kind of questions that might come up. One of the questions that that was posed to us is how do we validate complaints prior to starting an investigation? And the question I think behind this is sometimes complainants are not the parents, and so you know, you may have a neighbor that files a complaint or an attorney that files a complaint, and if that complaint is sufficient, then you know, we have to follow through the investigative process. And of course, that takes time out of everyone, you know, everyone's day to respond to that. And so the question came up is, you know, how do we know what complaints to investigate or what complaints not to investigate? Basically, that boils down to the requirements at 300.153 in the IDEA. That specific regulation sets out what a special education complaint must have in order to be considered sufficient. Some examples of those requirements are the complainant's name and contact information has to be on the complaint. The complaint has to be signed. It has to include an allegation with supporting facts that are related to special education. The complainant is required to provide a copy of the complaint to the public agency against which the complaint is filed. And so when we get a complaint in, what we do is do, you know, we roughly just look through it, do a spot check and be sure that all that information is there. If the information is not there, or if the issue is not something that we can investigate, then we notify the complainant to that fact. If it's something that the complainant can fix, in other words, if he or she just simply forgot to sign it or didn't submit the copy of the complaint to the public agency, we let the complainant know that and then follow up and make sure that that gets resubmitted appropriately. And then if it does, then we go ahead and look at it through the investigation process. If we get a complaint that does not allege something related to special education, then we issue a closure letter. Typically, those types of complaints are things related to 504 services. We get some complaints in which the parent is concerned about personnel issues or about alleged neglect or abuse. When we get those types of complaints, we notify the complainant about how he or she can address those concerns. If the complaint includes allegations of neglect or abuse, then we file a CPS report on behalf of the student, and we also notify the complainant about how to do that as well. If a complaint is sufficient, then what we do is we send out a documentation request letter to the complainant and to the public agency, indicating what those allegations are that we will be investigating, the documentation that we need to do the investigation, and then the due dates for both the documentation submission and for the due date for the investigative report. We, by practice, try to give the school district at least 10 business days to respond to the complaint. So it roughly amounts to 2 calendar weeks or 10 business days. If we get the complaint over, say, winter break or spring break or summer, and the district's not able to get the information to us in that time, then we can always extend that timeline. During the school year, for example, winter break, we typically just extend it initially so that we make sure that the district has the full 14 calendar days to respond to the complaint. At any time, either party can ask for the complaint to be suspended in order to go to local resolution. Local resolution would mean, could be mediation. It could mean just that the parties are wanting to meet an IEP team meeting to try to resolve the issues. It could mean that they are wanting to meet and draft a settlement agreement. If both parties to the complaint want to suspend the timeline in order to do local resolution, then that's what we do. We're allowed to put the complaint on hold and allow the parties time, however much time they need to try to resolve it locally. If it's resolved and the complainant withdraws the complaint, then the complaint is withdrawn and we don't take any further action. If the complaint is not able to be resolved locally, then we'll continue the investigation at the request of the complainant. We did get questions about COVID-related special education complaints. Peter Zerkiel out of Lehigh University actually did a survey of states and asked states to provide him with information about due process hearings and complaints that have been filed related to COVID. 90% of the states responded. And what basically it turned out is the topic that was of the most prevalent in terms of filings for due process hearing or complaints was IEP implementation. That doesn't really surprise us because IEP implementation is always the top issue that we see each federal fiscal year. And so it wasn't a surprise to us to see that nationally that's also the topic in the COVID related due process hearings or complaints. A couple of questions that we got are related to how are complaints handled in terms of like services being provided when schools were closed, but providing instruction. And the easy answer to that is just we have to treat those complaints just like we treat any other complaint. Because Congress and the USDE did not waive any requirements related to IDEA, then districts are still required by the federal government to meet those timelines for initial evaluations, to provide services set out in the IEP, so forth and so forth. And so that's how that's still the same standard that we've always used when investigating complaints. And right now that's really the crux of the information that I was asked to provide. Are there any specific questions?
Keith, I've been watching chat and I don't see anything coming up in chat specific. We've got a request for the questions and answers to be posted. I'm not sure if we'll be able to do that or not. We'll talk through that. But I don't see any specific questions about complaints.
Okay. There was a comment that says the complainant rarely submits it to the district. The complainant is required to submit it to the school district. So if you are a school district and you get notified of a complaint and the complainant has not provided that to you, then I need you to let us know as soon as possible. But one of the things that we always do our best to check is to be sure that the complaint was provided to the school district by the complainant. We do have the national survey. I can send it to Ed if you can send it out or post it or whatever.
Yeah, if you have it, I'm actually going to drop in the chat to everyone the document that Jose was talking about. We'll send it out too, but so people have it. But if you have the link, we can drop it in here as well.
Okay. Yeah, I will send that to you.
Keith, there's a few questions in the Q&A. Can you repeat where the requirements can be found in law?
300 point, well, it's 34 CFR 300.153.
All right, and how do districts handle situations of students not being able to wear masks or refuse to wear masks? Is remote learning option after attempts to an option?
That's really not really a complaints question. We get that a lot, and we've answered that in a couple of different venues. I don't know if maybe folks haven't seen it, but really if the reason the student won't wear the mask is related to their disability, and that would make me think that kiddo probably has a BIP, and so I would say your BIP probably needs to be adjusted to address that, and you would handle that whatever the best way is for that individual child. If a child is refusing to wear a mask and it's not, they don't have a diagnosis that's related to it, then they're subject to whatever disciplinary process the district has for everybody else. I mean, kids who have a BIP are also subject to that, but they have to go through the BIP first, obviously.
Sorry, I was panic reading, not critically reading. So there is one I've read beforehand about complaints, Keith. Do you have criteria for making determinations about the complaint? At one time I saw one shared by an ESC.
Is that for when you're talking about for closing a complaint before it's investigated? Is that what you're asking?
All this is criteria.
He's just
for
reading
making,
a question. Yeah.
yeah, criteria for making determinations about the complaint.
Well, yes. I mean, in terms of like whether or not it's sufficient, that's the requirements that we discussed at 300.153. In terms of like what we look for in raising an allegation, we review what's provided by the complainant, and we compare it against statutory and regulatory requirements. And if they're alleging something that would be in violation of special education statute or regulation, then that's the allegation that we raise to investigate.
Yeah, he clarified during the investigation.
Okay, so during the investigation, what we do is we look at the documentation submitted by both parties to the complaint. We gather the findings of fact and include those in the investigative report. And then we use whatever statute or regulation that was raised as the lens through which to review those findings of fact. In other words, if it's an allegation related to revision of the IEP, we'll look to 300.324 and use that regulation as our lens to see whether or not the district did what it was supposed to do as set out in the regulation. And that's how we determine whether the allegation is substantiated or not substantiated.
So there's a question that came up in chat, and I'm not sure Keith is going to be able to answer this. It's not in the Q&A, it's in chat. Actually, I know Keith isn't going to be able to answer this because I don't have the answer to it yet either. Well, maybe he does.
Is it the one about across state lines?
Yeah. Do you have an answer?
Do what?
Do you have an answer to that? I'm going to buy you pizza.
Yes. Yeah. So the way that we have, because we actually received a complaint similar to that question, except that the student was out of the country. And what we landed on is that it's not what the parent was wanting the school district to provide services to the student virtually, even though the student was no longer living in the US. And we said that was not an issue that we would investigate because the student was no longer within the geographic jurisdiction of the school district. In other words, the kid wasn't living within whatever school district it was. And so that school district no longer had the obligation to provide FAPE to the student. I would think that analysis would apply if the student is living in another school district other than your own, or
it's a little bit more complex because I think in that scenario, the district was asking them to provide virtual service when maybe they weren't already providing virtual services. And so this is what we're running into now. It's a little more complex than that because we have virtual services going on all over the place in the middle of a pandemic, which is making everybody think a little bit differently about stuff. And the scenario, the questions that we're getting is during the pandemic, mom and dad can't. This is just an example. Mom and dad cannot, they both have to work outside of the home. There's nobody to care for the child in the home during the day, and they're on virtual, they're receiving their instruction virtually. So we send them to live with their abuela who lives in New Mexico for 6 weeks or whatever. And so then they were getting speech services from a Texas certified speech therapist, or SLP, and but now there's this question of the SLP has a lot of reservations because she's not licensed in New Mexico. There is like that's sort of the difference, like because out of the country is a little bit even further removed, probably a quicker answer, but because that SLP now has hesitation about that. So that's what we're digging a little bit deeper on is like if we're in that scenario, it's just slightly different. So we're still working on that. I'll still owe you a pizza though, Keith.
There's another Q&A. What about a complaint that restraint or placement in AEP is being done too much?
Well, so if a student is being restrained,
So his question is actually, would we handle such a complaint
Yeah,
like that?
he added
Yes.
more, yeah.
yes, we would.
That's all.
Okay, I think we actually got through that. So,
Thank you all.
thanks, Keith. Okay, and now, Dr. Porter, now you're up to talk about mediation.
Well, thank you so much, Dr. O'Neill. So everyone should have gotten the ASTED list, got an email from me late last week. I mentioned it in the webinar that you were going to get it about mediation. We have, we received direction from the Department of Education Office for Special Education Programs that we needed to send that communication to y'all to clarify the fact that LEAs cannot use, cannot force parents or guardians or complainants in a mediation to sign that confidentiality pledge that is typically signed by parties at the beginning of the process. You can't make that a condition of participating in mediation. And so that's what that letter says. The mediation is still meant to be kept confidential according to IDEA, but you cannot condition participation on whether or not someone goes ahead and signs that pledge at the beginning. We've also trained our mediators on this and made sure that they were clear on it. And on an ongoing basis, and all the staff at TEA that help shepherd the process for mediation and assign the mediators, et cetera, are also aware of that. So I don't think this changes anything for an LEA, really. Substantively across the state, because the confidentiality requirement is still there. It's just whether or not you can condition signing that pledge as a condition for participation in mediation. Are there any questions about that? I just want to make sure that it's clear and folks have gotten that information.
So what if they did not receive the email you're referring to?
Then that means that they're not listed in ASTED as their district's contact for special education director. So ask them to go ahead. If you are the special education director, not just because you want to see it, if you are the special education director, go ahead and email our SPED inbox and sped@tea.texas.gov, and we will make sure and get it sent out to you. We will post the letter along with our response to OSEP on our website at some point soon as well for folks who are interested. It's not any more interesting than what I just said, though. When was it sent out? It went out last Friday. A week ago Friday. A week ago tomorrow, sorry. So for general updates, Ed, I don't know that I have any. Beyond that, folks are waiting with bated breath for the announcement around our dyslexia platform. We are a frog's hair away from having that ready to go. We had hoped we'd have it before the webinar today, but we don't. So look for that early next week. I've also had a couple questions about Chapter 89 revisions because we've been talking about that for some time. I'm just checking my chat right here to make sure I didn't hear back from our Texas Register folks, but they should be posted anytime now. They are ready to go and have been in the queue to get posted in the Texas Register for some time, so it should be pretty soon.
I do not have any updates today. Let's see. So somebody asked for us to repeat. So the dyslexia platform, we are very close to being able to announce what that outcome is. So we hope to be ready today, but it's not. So worst case scenario next Thursday, but hopefully sometime early next week. And
the email actually came directly from me, so.
And what I will say is some people are saying the link I sent out worked. Some people are saying it didn't. For whatever reason, the first time for me, it opened in Chrome. The second time I tried to open it, it would not open in Explorer. So, but either way, I'll send the PDF out. We'll send the PDF out along with the PDF report that Keith mentioned from Lehigh University. So. And then there's a facilities question. I don't know the question is, if we're bringing students in for face-to-face, does the 3-day rule still apply between use of a room?
You're going to have to look into our health and safety guidance that's posted on the web for that. And they also have, I'm not sure what it is off the top of my head, but there on that information, there is also a place to get your questions answered.
Check the chat. I don't see anything new in the chat.
I just posted something. I'm going to.
I just posted it. They're having trouble. I just put the actual like TEA webpage where the district and campus coordinator resources were posted. Maybe they can click on the link there. So
It just went to panelists though, Kim, so I just dropped it in for everybody.
oh, okay. Sorry.
Okay. Well, I think with that, I don't see any other questions. So we'll end a little early today, give people 15 minutes before they have to get on their next meeting. And we will see you all next Thursday. So thank you very much.
Thanks.